Hi, everyone. Welcome. We'll get started in a minute. Welcome, everyone. I see people joining the room, and we'll get started in a minute. Thanks for being here today. Welcome. Thanks for being here today. We'll get started in a minute if you've just joined. All right, I'm going to get started with an introduction so we can take advantage of all the time that we have. Hi, everyone, and welcome. We're so glad you could join us today. Feel free to say hello in the chat. Let us know your name, where you're joining from, or what organization you're with. My name is Rachel Roth. I'm Senior Director of Grants and Programs at the Foundation for Financial Planning. If you just logged onto this without knowing much about it, you're in for a treat. Today's webinar is all about heirs property, what it is, why it matters, and how financial professionals can help clients protect and maximize this valuable asset. We're thrilled to be joined by Dr. Karama Neal from Asset Funders Network. As a reminder, this webinar and others in FFP series are eligible for CFP and AFC continuing education credit. We'll submit the CE credit to CFP board, and then the AFCs in our audience will need to submit to AFCPE themselves. I'll let you know the code at the end of the webinar, and we'll also email it out. Jordan, you can switch. Yeah. So before we dive into today's presentation, I'd like to take a few moments to share more about FFP and our mission to expand access to pro bono financial planning for those who need it most. We know that millions of Americans need but can't access quality, ethical financial advice and guidance. More than half of Americans don't have savings to cover a $1,000 unexpected expense. And of course, there are groups that are especially at risk: people facing serious illness, victims of natural disaster, veterans, women, members of the military. So for more than 30 years, we've been building a movement to help people in need improve their financial lives by expanding access to pro bono financial planning. Next slide. And we do this in three major ways. We develop and support pro bono financial planning programs in partnership with nonprofit organizations across the country. We provide grant funding and technical assistance and a wide variety of other resources to ensure that these programs are reaching those most in need of free financial advice. We recruit and train financial advisors to do pro bono service, and we connect them directly to volunteer opportunities through our volunteer platform, probonoplannermatch.org. And finally, we lead the movement to foster pro bono service within the financial planning profession. We conduct original research, public awareness, and more. Next slide. We also offer a number of resources to support pro bono financial planning. We have our pro bono financial planning volunteer training. It's a free 1-hour online resource that helps financial planners and whoever wants to take it, nonprofit professionals, really understand how to provide service to underserved members of the community. The training's approved for 1 hour of continuing education credit by the CFP board. And then to complement the training, we also offer worksheets, webinars, user-friendly disclosures, such as a sample letter of engagement, privacy policy, and more. Pro Bono Planner Match is another resource that I want to highlight. Mentioned it in the previous slide, but it's the first of its kind platform connecting CFP professionals with volunteer opportunities at nonprofits. So nonprofits create an account on the site and then post opportunities for CFP professionals to provide free, no strings attached financial advice and guidance to people who need it, who don't have access to it. And then CFP professionals can register on the site and then browse opportunities and sign up for opportunities that interest them. I'm happy to provide more information, reach out to me, and I can walk you through it. And then finally, for advisors who take the training and connect with one of volunteer opportunity through one of FFP's grantees or through an opportunity posted on probonoplannermatch.org, we offer E&O liability insurance. So I encourage everyone here to join the pro bono movement in whatever way you can. Sign up to receive our pro bono news, support our mission with a gift. Your work and support really do have a meaningful impact on the millions of individuals and families in need, and we wouldn't be able to do it without you. Slide. And so to get to our webinar content for today, we're honored to be joined by Dr. Karama Neal, Strategic Project Director at Asset Funders Network, where she leads work on heirs property, an issue she knows both professionally and personally. Karama brings a wealth of experience from her time as president of Southern Bancorp Community Partners and as a USDA administrator, where she championed rural economic development. Her passion for this work is rooted in her own family's experience with rural heirs property in Arkansas, which led her to found the Heirs Property Information Project and advocate for legislative change. Her deep experience spans genetics, bioethics, and impact investing, and she brings all of these things to her mission of helping families preserve wealth and stability through property ownership. So please join me in giving a warm welcome to Dr. Karama Neal.
Thank you so much, Rachel. I really appreciate the very kind introduction. Thanks to you and to Jordan and to the FFP team for suggesting this, this continuing education session. I'm really thrilled to be here. Really thrilled to have all of you all who have joined us from all over the country. I think I saw at least one person from outside the country as well who put their name in the chat. Really thrilled to have you all here. This is a really important issue. It's one that I think a lot of folks don't know a lot about, or they don't, or even if they sometimes end up knowing it personally, they may not actually know it's a name or know that it's an issue and that it has such wide and significant impact, not just in the United States, but also in other places around the world as well. So again, very much appreciate being here. And so let's jump right in. I'm going to share my screen. Give me just one moment to do so. All right, you all should have full screen now. And so again, we'll go ahead and get started. As Rachel said, my name is Karama Neal. I have been doing this work for a number of years, since 2013, when I started an effort to lead a statewide grassroots organization in Arkansas to lead the effort to get a particular piece of heirs property related legislation passed. We'll talk a little bit about that as we go forward. But this is rooted in my family's ownership of this type of property. And part of what has been really nice about doing this work that I have a personal interest in professionally is that it's helped me understand the true scope of this work and not just limited to the experience that I've had directly with my family. In addition, I also work as a mediator for families who have heirs property. And so I really help them, much like you all do in terms of providing direct services to people, help them think about their future and their plans with their family and with their family's property. So today we're going to do a number of things. I think probably you all have seen this list of learning objectives. And so hopefully that's what you're here for. We're going to talk about what heirs property is. We're going to talk about the opportunities and the challenges that are presented by heirs property. We'll talk about what it means for you all as financial planners to be helpful to families who either have or could have heirs property. And we want to make sure that you all have the resources to support your conversations with your clients. And to find out more if you need to, both for yourself or for them. We'll focus on those items through this agenda. We'll first do an introduction and talk about heirs property, just to ensure we're all on the same page about what we mean when we use that term. We'll talk about why it's an asset. We'll talk about the challenges that asset sometimes has. We'll talk about strategies for preventing heirs property. And then we'll talk about strategies for retaining, for resolution, and for use of heirs property, because it is an asset and we want folks to be able to use it. And we certainly want to retain time for some Q&A. I've shared with Rachel and Jordan that if there are, you should feel free to put your questions. I think in the Q&A is where you're hosting those. So feel free to put your questions in the Q&A. If there are some that are, highly timely and fairly quick, we can go ahead and answer them during the presentation and don't mind being interrupted at all. Otherwise, we'll save the questions to the end and we'll have a robust discussion at that time. So let's first talk about what heirs property is. So heirs property is real property. So land, houses, other buildings that are attached to the property. So real estate, real property that is passed down to multiple family members via an informal inheritance. And this can occur across multiple generations. So let me say a little bit about what we mean by that. Informal inheritance, what that means is that there's not been a legal sort of probated will or other sort of estate planning that has been activated such that the heirs to that property are legally recognized as owning that property. So they do own it because that's what the default law is. Someone passes away, their children are their heirs, the children own the property. But that's not necessarily recognized legally because there's no documentation of that, because there has not been a fully probated will or other estate planning document to show that. This can happen across multiple generations. So, just a very quick example I gave, someone passes away, their children inherit the property. If one of those children passes, then those children, the grandchildren of the original owners, would then inherit a portion of that property. We'll talk about what that means in just a moment. Heirs property disproportionately occurs in low wealth families. This is for a number of reasons. I mean, it does take funds and access to legal services, not only to create a will and estate plan, but in the case of a will in particular, to probate that will. And so sometimes that can be an issue as well. And so if folks don't have access to that because of financial or other reasons, to trusted financial services, to trusted legal services, ethical legal services, then they may not have the estate planning in place to ensure that their property is passed down in a way that is not an informal inheritance. Because of this can in fact impact generational wealth transfers, can affect housing if that property is a family home. It can affect neighborhood and community resilience and financial health. If you have neighborhoods with significant numbers of properties that are heirs properties, there can be challenges sometimes with that neighborhood because of the upkeep of that property. Again, we'll talk about that more in a moment. There was a question, so a few of you submitted questions as you registered, so thank you for those. It's great to have those. Of course, other questions is welcome as well. One of the questions that was submitted was, a question basically sort of implying, is heirs property sort of only found in the South? And in fact, it is not. It's found in all areas. It has been, prior to the last 10 years or so, probably most of the discussion you would hear about around heirs property, if you heard anything at all, was thinking about rural property, often in the South, often owned by African Americans. That is where the history came from. That's where a lot of the work previously has come from. But certainly in recent years, there's been a huge uptick in the research and the work and the engagement around heirs property in urban areas and suburban areas throughout the country. And we'll talk more about this, and I'll show you a map and some other data in just a few moments. So as we move forward here, I want to make sure folks are understanding what this is. So feel free, again, to make sure that if there are questions about what heirs property is, do feel free to ask those so that the rest of the presentation certainly makes sense as we move forward. A little bit about scope. There are been a number of studies, particularly in recent years, around the prevalence of heirs property across the country or in particular states. There are a few estimates here. Based on how folks are able to go into property records and determine likely heirs property. It's often very difficult to confirm that something is heirs property just by looking at the property records, the county property records. But you can also often determine likely heirs property. And so that's what a lot of folks have done in various ways. And they get estimates. For example, an estimate of $32 billion worth of residential property. And this is in 44 states. And the emphasis here is this is only residential property, right? So this is not agricultural property or those kinds of things, which also can be heirs property. There's another estimate of $41 billion worth of property and more than 444,000 parcels, 9 million acres across the country. And you'll see again, the links are provided here on the slide. I think all of you know that you'll receive these slides afterwards as well, so you'll have access to these links. In Florida and Pennsylvania and Texas, those are just three recent estimates around the prevalence of heirs property in those particular locations. I raised this here because I want you to see sort of the scope of that. Like, what are we looking at in terms of numbers of properties, in terms of value of those properties, and also the geographic scope, right? We're looking at, and just in this example, these are just some recent numbers: Dallas, Fort Worth, Texas; Philadelphia, Pennsylvania; Duval County, Florida. That's Jacksonville, Florida area. And these are just some, right? So again, we're seeing the breadth of heirs property, not only across types of communities, rural, urban, suburban, but also across the country as well. There are two key features that we need to be thoughtful about when we're thinking about heirs property. One is fractionated ownership. So when someone dies and their real estate, their property is inherited by more than one person, each heir, excuse me, inherits a fractional ownership interest in the entire property. So what this means is, and I've evidently, there have been some places where people have sometimes misconceptions about this. The easiest way to think about this is in terms of, for example, agricultural or rural property, where let's say there's 100 acres of property that someone has passed away and it's been passed down to their two children. In that case, if that's heirs property, it is not the case that one child can go and point to the western half of the property and say, this is my half, and the other child point to the eastern half of the property and say, this is my half, or the north half, or the south half, or however you want to divide it. Unless that is legally done, that's not the case. What is the case is that both of those children in this small example have a 50% share of the entire property. So they co-own the entire thing, hence the name, the legal name, co-tenants. They're called co-tenants of that property. And because they can't point to any particular spot, you can't say, well, I own 50 acres and you own 50 acres. No, the correct response is, I own 50% and you own a 50% interest together. Because that is ownership of the entire property, any sort of major actions affecting the property require all the co-tenants to sign off, right? And that you can see here where that could create some challenges with managing a home or managing agricultural land or timber production or those kinds of things, because you have to have all of the heirs sign off because they all have an interest in all of the property, not just a particular portion. I think sometimes that can be a misconception that folks will think, well, I own this many acres, and it's just really not the best way to say that, because it implies that you can point to a particular acreage. You could go stand on a particular part. This makes more sense when you're thinking about a house, right? So if it's a home, it's really hard then to think about, well, which half of the house do I own? Which half of the house does my sibling own? In fact, you all own half the property together with your shared interests. The other piece that is really critical to heirs property, one of the key features here, is clouded title. And by that we mean that the people who own the property, the people who legally own the property, the heirs to the estate, their names are not represented on the title, on the legal title. So there's no paper trail that shows that this person has an interest in that property. The family might know it. Everybody knows these are the children of the person who owned this home, who's now deceased. And so they are the likely assumed heirs. But there's not necessarily a paper trail for that. And so that clouded title can be very challenging. I think I would just encourage you to think about, like, if you have a home and you are in this situation, we'll keep with the one sibling, for example, with a one sibling. How, and let's say you're living in the home, the sibling is not, the sibling has moved away, but you're living in the home. How could you get a home repair loan if you can't show ownership of the property? Your name is not on the deed, right? And so when I talked about neighborhood resilience earlier, this is part of how this comes into play. Oftentimes, heirs properties are not as well maintained, in part because folks don't have access to capital, because they cannot show legally ownership of the property. And even if they could, that ownership is shared with someone else. And so they would have to have all the parties who are heirs, all the co-tenants, to use a legal term, come together to take any action. That can be challenging for some financial institutions to work with. Again, I'll pause if there are questions that particularly about what heirs property is or how it operates. I think I'm happy to address any of those just to ensure that we're all on the same page as we delve a little bit deeper into this topic. So hearing none, I want to continue on and think about a particular piece of legislation. We won't go into depth on this. Folks are certainly welcome to Google the Uniform Partition of Heirs Property Act. But I share it here for a couple reasons. I share this map for a couple reasons, or several reasons. One, this is a particular piece of legislation that came into play a little over 10 years ago through the Uniform Laws Commission. They're a commission based in Chicago. They've been around since the 1880s. They create model and draft model legislation that then, through uniform law commissioners in every state, sometimes try to get those laws passed in their state. This particular legislation is focused on heirs property, and I share it not necessarily to go in depth on that. If folks have questions about the UPHP, I'm happy to answer those in the Q&A part. But I share this because this legislation is specific to heirs property, because you see all the blue states are the states where this law has been passed. It shows you the breadth of interest in heirs property, right? This is an heirs property law, and I believe Montana was either the second or the third state to pass this law. I led the effort to get it passed in Arkansas. We were the fifth state to get it passed. New York has one of the strongest versions of this legislation in the country, and their effort was led by folks in New York City, a highly urban area. Since I pulled this map on February 7th, since then, both Rhode Island and North Carolina have also introduced legislation. That's what the green means. The green means it's been introduced. The blue means that it has passed at some point. So we're now up to 25 states and jurisdictions that have passed this legislation. I include jurisdictions because you'll see the District of Columbia, you'll see the Virgin Islands have also passed this legislation. So it's sort of marching across the country. And again, I mention this here not to advocate for any particular legislation, but to be very clear to help folks understand that a piece of heirs property specific legislation is of interest across the country, not just in the South, not just in areas that are predominantly rural or agricultural, but really there's significant interest across the country, and that interest continues. Rachel, you're coming on. Is there a question?
Yeah, there's a few questions.
Please.
And yeah, so I thought we could go through a few.
Perfect.
So what's the most efficient way to determine if a person is related to heirs property?
So really great question. And you will find, particularly in complex cases, there may be folks who have an ownership interest and don't know it because it's been some time ago. In a simple case, you can imagine a family who owns, say, a home, and the parents pass away, their children perhaps live in town or live elsewhere, but they didn't have a will. And so then that property is passed down to the two children. In that case, it's pretty straightforward, right? You know your parents passed away. You know they owned that house. You know they didn't have a will. And so you know you're the heirs because you know you and your sibling. And so it's pretty clear that you are the heirs to that. Where it becomes much more challenging is if this persists over multiple generations. That was in one of the early slides. We talked about how this can persist over multiple generations. And in such a case, I mean, I'll talk about just briefly about my own family. One piece of heirs property to which I'm a co-tenant, my great-great-grandfather purchased it in the 1800s. And so, there are a lot of us now, as you can imagine. And so, I'm sure I have relatives who don't know the property exists, certainly don't know that they're heirs to it. And so that is part of the challenge when we talk about how to resolve this and how to make sure that people can use that asset to their benefit. They can rent out that house. They can live in that house. They can improve their home. They can lease their agricultural property, right? Do the things that you would want to do to make that asset truly beneficial to the family. It requires identifying who those heirs are, really is doing genealogy work. It's, building a family tree. Having those conversations with family members to understand what property was owned, where it is. A lot of this can take place just in informal conversations with family members at reunions or other kinds of gatherings. But it also sometimes is a legal issue as well.
Yeah, and there's a few questions about siblings dying or a spouse dying. Like, what is the other spouse entitled to, or the sibling?
Very good questions. And so I always, when I do this work, I always emphasize that I'm not an attorney. So I'm not an attorney. But I will say that the laws around inheritance, so the default laws around inheritance differ in each state. So that's not something that one could necessarily comment on. Even if I were an attorney, for example, in Arkansas, I wouldn't be able to comment on that for every state. It is important to recognize that there is, if you don't have a plan yourself, your plan being your estate plan, your will, your trust, you don't have a plan that is then executed, because the plan I used to have a boss who said you have to plan the work, you have to work the plan, right? So if you have a plan, which is a will, and that will is not probated, then that plan didn't get executed, right? And in those cases, either you don't have a plan or the plan doesn't get executed. The default pathway, which is the default inheritance laws of your state, are the ones that take effect, right? And that will determine, for example, if a spouse has a right to a third of the estate, or if it passes down to the children by default, or if you can even disinherit children. All those laws are going to, again, they're going to differ state by state. Those are really valid questions, and they are relevant to this. They differ state by state, and so you'll have to sort of look into that at your state level.
That's helpful. I'll just do one or two more.
Sure.
One's very, so in terms of the payment of real estate taxes, like how do you decide which of the heirs is responsible for that?
It's a fantastic question. If we talk about what the ownership interest is, part of what we talked about is that everyone, all the heirs own that property collectively, right? And they may own a portion depending on what their interest is, right? In the example of two children, you can imagine the taxes, maybe we split it in half because there's two of us, right? If it's three children, maybe you split it in thirds. Maybe if it's two children and one of those children had three children themselves, right? Now you've got one sibling paying half. And if the other sibling has passed away and left their one half interest to the three kids, now it's one half divided by a third, which is what each of those three children is responsible for, right? So you can see the math. You just do the math. You do the family tree and you do the math. So the basic question, who is responsible, is everybody who is an heir, right? And so, for example, I can remember my grandmother going around to all of her cousins and collecting the money to pay the taxes, and everybody knew what their share was, and they would pay it, and the taxes would get paid. In practice, that's much more challenging, right? So you can imagine a situation where someone, again, is not living in the property or on the property, may not even be in the same state or in the same area. They may not know the taxes are due, right? Um, Even if in most cases, you're going to have someone's name who's associated with the property, someone who is going to actually get the physical tax bill or the email with the tax bill on it. If that person doesn't communicate with everybody else, they may not know the property's there, that the taxes are due. They may not know what the taxes are. You can also imagine a situation where, someone is getting the tax bill. They live away from the property. They're not particularly concerned about it because they don't live on the property. And, I'm not that engaged with it. They don't pay the bill. Well, how do the people then who are using the property, who are nearby, how do they find out what the bill is and ensure it's paid on time? Most of this work is often public record, but that doesn't mean that everybody's necessarily making a note on their calendar to say, go check and see what the taxes are and collect money from all your kinfolk to make sure they get paid. Right. So in practice, yeah, everybody who's an heir, you figure out your interest, you divvy up the taxes, you do the math, and you pay the taxes. In practice, that can be a lot more challenging. As you can imagine, heirs property can be very susceptible to tax foreclosure for this very reason, because folks don't know they own the taxes, or they have not been keeping up with the taxes. They're not sure who's been paying taxes, if they're paid, if they're on time, and then you can end up in a situation with tax foreclosure where then that asset is lost to that family.
I'll let you continue on with the presentation, then we'll get back to some questions later.
Sure. Yeah. Feel free to interrupt. These are really good questions, so I appreciate you all asking them, because it does help us get into the nitty gritty of what it means for you all to be thinking about this issue as financial planners. Okay. So one other thing I wanted to say before I leave from this slide is that what we're calling heirs property, and that's the legal name for it. We've talked, if you're an attorney or folks like that, if they know about this, that may be the name they know it by. That's not necessarily what it's called in all these places. Just like all kinds of other regional dialects and regional words, heirs property has similar kinds of things. As I've done this work nationally, there's quite a bit of activity around heirs property in Philadelphia area, and even though they haven't passed the UPHPA in Pennsylvania, there's a lot of engagement in parts of Pennsylvania, particularly Philadelphia, around heirs property. They don't call it heirs property at all. Like, that's not, they call it tangled title. And so they talk about tangled titles and how do we address tangled title. And tangled title here, that's what I'm saying, tangled title is the same thing as clouded title, meaning that the title is not the names that are listed on the title are not the names of who actually owns the property. So heirs property is not necessarily always called that. I remember several conversations I've had with people where I've talked about the work that I've been doing over the years, particularly when I was trying to get legislation passed, back more than 10 years ago now. and would talk to people about it, and they'd say, "Oh, this is really interesting. We have family land," and they would go to describe their family's property and how they manage it and what they've done and what they haven't done. And more than one time, it's occurred to me that like what you are describing is heirs property. You're calling it family land, and that's I often call it family land too, but that's how they knew their property. Um, it was heirs property. It met that legal definition of heirs property, but that's not what they called it. So as you all are thinking about your work, again, I was pleased to see so many people come in from all over the country who are doing this. Recognize it may not be called heirs property where you are. And that does not mean that it's not heirs property. If you're having those factors, you're having fractionated ownership, you're having clouded title, the names of the owners are not the names that are actually on the deed, then you're likely dealing with some sort of tangle title heirs property issue. And a lot of what we're talking about here is going to be relevant. So heirs property comes up because it's often perceived of as problematic, but I always like to help people think about it as fundamentally, this is an asset. If it were only problematic, if there were only problematic aspects, if the problematic aspects were truly so overwhelming, then people would walk away. They would not deal with it. In fact, though, it is an asset. People see the value in the home that was the family home, in the land that perhaps was a family farm some years ago. I should say, in fact, in the state of Missouri, the Uniform Partition of Heirs Property Act, when they passed it as the Save the Family Farm Act, because it does do exactly that. So fundamentally, these properties are assets. They are economic assets. They can be cultural or sentimental assets, where, if it's property where people have lived in that family for many, many generations, if it is a family home, it can be a cultural or sentimental asset. It can be a foundation for wealth building. I think that's a really important factor that sometimes gets missed in discussions of heirs property. Not only can it provide housing and facilitate home ownership, because again, this is a home you already own by inheritance, it also can provide housing for others. I worked with a family in my mediation practice who had a family home. They had all moved away from the rural community where the home was based, where they had grown up, but they were renting out the home. And so that was providing housing for someone else, and it was providing income for the family. And so that, home housing and home ownership is an important feature. It can be a basis for small business development. I talked with a researcher, an urban planner who was doing research on heirs property. And part of what she found is that she was looking at barbershops in this one in Memphis. And she found that one of the older barbershops in the community, in fact, had been a family owned barbershop for many generations. And part of what facilitated it being that was because the property was heirs property. And so the family retained that property. And so because the family had it, because it already had its barber chairs set up, they were able to continue that business for many generations because they owned that property, in part because they owned it as heirs property. As we talked about before, it can have community implications. So it's important for community development. If it's agricultural land, it can be important for commodity production, for food production, timber, fiber production, all those kinds of things. So heirs property is fundamentally an asset. Sometimes people think about it all as only a problem. I think that's the incorrect way to think about it. I think as financial planners, you all would agree that it is, in fact, an asset. It is, however, an asset that has some challenges. So because of the number of heirs that are involved, and you've talked about some very simple situations with someone passing away with just two children, but you can imagine that can get very complicated very quickly as generations go by. If these clouded titles, these tangled titles, are not resolved such that the names of the people who own the property are what's represented on the deed, and that's done in a way that's feasible. Sometimes with that deed showing a trust or an LLC as opposed to lots of individual names. Because when you have a lot of individual heirs that are all co-tenants to a piece of heirs property, it makes that property vulnerable to predatory investors, coercive sales, particularly in places with rising property values. This is part of the reason the Uniform Partition of Heirs Property Act and other types of heirs property legislation and work is happening to such an extent in New York City, is because of the rising property values, and people see a property that they're interested in, and they are able to talk with families who have an interest, but perhaps aren't interested in the property, and then buy that interest from them, and then have access to the property in ways that maybe some of the other families are not, the other family members, other co-tenants are not pleased about. We talked already about challenges with maintenance and management. This is particularly important with housing or buildings that are on heirs property, but it's also important for other types of property as well, making sure that the lands are well kept. It can be a barrier to wealth generation, because you don't have oftentimes have the access to dollars to make the investments to improve a home or a property. You're not able to generate wealth as easily from it. Again, that barrier is not, it may be that the people have good credit and they're able to get a loan on their own, but because the property, again, the title is not listed in the names of the people who actually own it, it's difficult to use that property as collateral for a loan, such as you could then use that for home improvement or other kinds of purposes. All of these things make it vulnerable to land, home, property use. We talked about tax foreclosure. That was an excellent question that someone asked before. Property tax foreclosure is an issue oftentimes with heirs property, because who is getting the notification? Is that information being passed down, or folks sharing in their responsibility to pay the taxes, etc.? And again, we talked about issues and impacts on communities. So it's something to be thoughtful about there. So given that, how do we prevent heirs property? So I really want to emphasize here comprehensive estate planning. Oftentimes with heirs property, you'll hear folks talk a lot about wills and wills clinics. I'm all for wills clinics. I've been a volunteer at wills clinics. I'll tell a story about that in just a second. But it is absolutely critically important that there be comprehensive estate planning. Let me give you a couple things to think about there. If you have a simple will, and I've seen this happen more than once, if you have a simple will that simply says, someone goes to you and they say it's a quick, maybe it's a wills clinic, someone's sitting there, they're getting their will done. They say, leave my house to all my kids. And then the attorney dutifully writes down the names of all the children and says, this house is going to go, at the house at this address is going to go to these 3 children, and writes down the names. And let's say that will is probated, as a will should be. At that time, then, those 3 children in this example now collectively own that property. That they own that property undivided. So while it meets the standard of having the names listed on the deed of the people who actually own it, those are the 3 kids, because the will said the 3 kids own it, and the will was probated, so now the 3 kids own it. You still have all those 3 kids owning fractionated interests, right? So in order for them to do anything to that home, if they wanted to get a home improvement loan, if they wanted to sell the home, if they wanted to rent out the home, really all 3 kids have to sign off every time anything significant happens, because all 3 kids are listed on the deed of the property. So while that is a will, and in that example, the will has been appropriately probated, it's not necessarily the best example, the best solution for how that family might want to manage that property, even if they want to retain it in the family. Perhaps only one child should have the property, or perhaps they want to set up a trust so that someone is managing it, so you don't have to have necessarily all 3 people involved in every decision. So thinking about that really from a comprehensive state, not just sort of saying, oh, just leave it to all my kids and pass it down. Thinking about that is really important. The other thing I would say, as we think about comprehensive estate planning and why that's so important, is sometimes folks don't know what is required once you have a will. So as I said, I volunteered at wills clinics did for a number of years, mostly 10, 12 years ago when I was doing this work. And I'm not an attorney, as I said. And so part of my job and what I really enjoyed was being a witness. And so, folks would do their will and they would call me over and say, and I'd have a conversation with the person and, convince myself that they were of sound mind. And then I would watch as they signed the will. Honestly, the relief on folks' faces when they did that was so wonderful. It was really great that they had access to those estate planning services. So I did this years ago, haven't done it in some time. Last summer, I got a call out of the blue from someone who, they called me up. Is this Karama Neal? Yes, it is. I'm calling for you because your name is on my mother's will. And I said, who is your mother? I have no idea what this person's talking about. Don't know who. It's completely out of the blue. It turns out her mom was somebody whose will I had witnessed. We figured it out based on when it happened, where it happened, that kind of thing. So I'm fairly sure that's what it was. And the woman who had passed, whose will I witnessed, she had passed away in 2021. Well, this conversation is happening now in 2024. The woman's been passed away now for 3 years. The daughter is holding a piece of paper in her hand, I was presuming on the phone. She says, I have my mother's will here. It says that me and my brother own the property, but I don't know what to do with it, right? So it's now been 3 years. She's had the will this whole time, and she doesn't know how to probate it. And so thankfully she did call me. My phone number wasn't even on there. She just happened to find me and happened to look me up. And I was able to tell her how to look for probate attorneys, that she needed to do that, what her next steps would be and how she needed to take them soon, because in Arkansas that will sort of has a bit of an expiration date after 5 years. So again, this is why comprehensive estate planning is so important. I think you all as financial planners are in a position to help emphasize these kinds of things to your clients. Yes, you want a will. Make sure that will is crafted in a way that to really do what you want it to do, and make sure your heirs understand what to do with the will once you're gone. Because obviously, in the case that I just mentioned, that was not the case, and this family had been sitting on a will for 3 years and didn't know how to proceed. Family communication is important. State policy is important. There are different ways that there are some states that offer what's called a transfer on death deed or a beneficiary deed. It's called different things in different places, just like so many other things as we've talked about. Those kinds of policies allow folks to transmit certain pieces of their estate under a certain value, typically with a piece of paper. It basically says, when I die, my child gets this person gets this house, or this person gets this vehicle, or whatever it might be. And that can be a really straightforward way to transmit property without having to go through the probate process, hire an attorney to go through probate, et cetera, et cetera. So all these things are important. Again, you'll have to look at your state and specifically to determine what options are there, particularly in the context of state planning, of state policy. But think really helping your clients think about comprehensively about their estate planning is going to be an important thing for them to do. We want to think about preservation and resolution. So we've talked already about home repair, property maintenance issues, how important that is. Combating predatory investors. And I say predatory just because in many cases you're dealing with a family who does not want to sell their property, who is in fact being forced to sell their property because of how the laws in that particular state are set up. Avoiding fraud. There are cases of probate fraud where someone will claim to be an heir and they're not, and that can be a problem, and so it's something to be thoughtful about as well. Insurance is important as you think about property preservation. I mentioned the family that is, has their family home that has been heirs property, they're renting it out. It's important that they figure out a way to purchase insurance on it, even though there's more than one person who owns that property, more than two people. It's not a couple, right? It's multiple children who own that property. They need to figure out how to buy insurance to make sure that that home is protected, and sometimes that can be challenging. Much of what we're talking about here, particularly for families who want to retain the property together. They don't want just one person to own it or just, one set. It's the family land, as many people call it. Putting in place measures to facilitate collective ownership and collective management of the property is a really critical, important tool. And sometimes that's a trust. There were a number of questions earlier on about trusts. Sometimes that can be a trust, it can be an LLC, depending on what the family wants to do with the property, depending on who wants to be involved, that kind of thing. That will determine, they can work that out with an attorney if they're choosing. So what processes can be in place to facilitate that? But that's an important thing to consider as well. And there may be cases, in many cases, where it's possible to consolidate or to clear the title. And by that, we mean getting at least some, in the case of consolidating, or all, in the case of clearing, the names of the heirs found and addressed, understand what their portion of what their interest percentage is. Do they own half? Do they own a third? Do they own 1/10, 1/6? What is the portion that they own? So that then the title can reflect what the true ownership is, even if that is sort of one level removed through a trust or an LLC. So again, I think part of, as financial planners, part of what will be helpful for you all is to help people who do own property think about, if you are the owner of this property, how do you intend to transmit it? How do you intend to, what do you want to do? Do you want to leave it to more than one child? If so, why? And how do you sort of facilitate that? Is it possible to leave it to one to make the ownership and the management of that more strategic? Is it something where maybe they want to sell the home and divide up the money so that both children, or all the children, can share in the dollars on that? I think it's also important as financial planners for you all to recognize, and there was a question about this earlier, like how does somebody know if they have an interest? That's an important question, because that's something that can be planned for. If someone has an interest in a property, and let's say they don't have any children, but they own a 1/4 interest in a property, for example, they may decide that 1/4 interest is going to go to a niece or a nephew or to a cousin or someone else who has interest in it. And they can be intentional about that interest, which is then not the full ownership of property, but an interest. They can direct that in their estate planning and in their plans. So again, as financial planners, I think that's something that you all can be thoughtful about, to help people think about, what they're going to do with their properties, how they're going to preserve it, and if they want to get involved in a process to resolve it, so that again, they are in a better position to make full use of their asset. So let's talk a little bit about use. I think there are a number of things to think about here. As I said, there are definitely families, particularly larger families, who may have been over sort of multiple generations. Oftentimes, at least in my experience, I've seen people want to retain collective ownership and collective use of the properties. So in some cases, that may mean that, we're going to own this together. And if it's timberland, we're going to cut the timber, at the appropriate times, and we're going to divvy up the proceeds based on our ownership interest. It may mean, we're going to share the profits from both the profits and the responsibilities of this rental home. So the families may want to use it together. The families may say, you may see this particularly in the case of a home, for example, you know what, baby sister, you're living in the home, you're taking care of it, you have all this time. I'm going to either give you my 1/2 share if it's a case of 2 siblings, or maybe you can buy me out, buy my share out. And you're going to be the sole owner because you're living there already. You've been paying the taxes. And you've been responsible for it. And that's where you're raising your kids, whatever that may be. So you may have a situation where the property, the goal of the family is for there to be a sole owner. And again, these are conversations that you all could potentially have with your clients to help them think about what the assets are they have and how they want to use them. There also could be a sale. I mean, the family could decide, none of us want to really be engaged and manage this property. We'd rather have the monetary value from it. And so they arrange for sale of that. So all of those are options. I think it's also important for families to think about what they can do with their properties. There are options out there for folks to think about that. Again, we talked about sort of agricultural or timber, other kinds of productive lands. Sometimes that's very obvious, but sometimes it's not obvious that you could also maybe put solar panels on there or use it for recreational purposes or those kinds of things. Energy production. So there are a number of ways that people might use their properties, whether there's a home on it, other buildings on it, or it's a vacant lot. Even I've seen people talk about, like, could they have a vacant lot in town that is heirs property? Maybe the house did become dilapidated and has been torn down, and they want to use the property to make sure it's a playground for the neighborhood, or they want to use the property as a community garden, or those kinds of things. So I think, again, there are lots of different options, and I think, again, you all as financial planners are in a position to help encourage people to be intentional and being thoughtful about how they want to use their property. One of the things, again, that has happened, particularly in recent years, is there's been more attention to all of the types of services that are needed to help families with heirs property truly maximize their asset and use it in ways that they want. Financial planners, we've talked about, you all play an important role in that. Obviously, I think it's pretty obvious that estate planning and property law attorneys will play a significant role in that. Financial services are really important. There's increasing work now with lenders to help them think about ways that they can lend to families who don't have a clear title, right? You're clear who lives in the home. Maybe you're clear who some or maybe all of the other heirs are, other co-tenants are, but you need a loan to fix up the house, or you need a loan to plant the timber or plant the seed or whatever it may be. And in those cases, financial services that have loan policies that allow them to work with families that have heirs property are really important. I mentioned that I serve as a mediator in my practice as well. And I think that can be a really important tool to help families who are not aligned around how they want to use their property, how they want to proceed. A mediator can help them come to a self-determined decision around how they want to move forward with their property. Housing counselors, credit counselors. We talked a little bit about policy advocates, researchers who help understand the breadth and the opportunity that this issue provides for families and communities. All of those folks are really important. Rachel, please.
Yeah, actually, so we've gotten a few questions about some of our participants' experiences with clients who
Yes.
have heirs property issues.
Excellent.
And I think this slide is relevant because they might have to go to external sources and experts to help solve those issues. So I was wondering if you could just provide some insight on a few of these examples.
Absolutely.
So someone wrote, what if the parents passed away as well as the siblings? I think they have a client where the youngest sibling is left in the house but can't get title under his name or have the ability to claim homestead exemptions because it's still showing up on the appraisal district as the estate of the mother.
Yep.
Like how to get it transferred over to him. He's been paying taxes on the property for over 20 years. And he spoke to an attorney, but they said he had to contact the deceased siblings, ex-husbands and wives who he doesn't have communication with.
Yeah.
So what options does he have?
So these are really good questions. As we said, the default laws around inheritance differ state by state. It sounds like this person has already talked to an attorney and has had some guidance there. If there truly is no communication with the spouses of the deceased siblings, if there really is no ability to contact them either directly or through an attorney, so I would encourage consideration of both of those paths. Then there may be a way for the attorney to go, and in some places, again, not an attorney, and want to make sure that recognize that there are different laws in different states. But in some places, a quitclaim deed can be something that can be issued. An attorney can say, you post appropriate notification, right? So property rights are pretty important in the United States, and so it's going to be very hard to just sort of say you no longer have a right to that and move on really quickly. But with appropriate notification, appropriate legal support, you can sort of say like, okay, you have 30 days to respond to this. You have 60 days to respond to this, whatever the particular law in that state requires. And if there is no response, or if the response is such that is, take me out of it, or whatever that may be, then there may be a way to move forward. But typically it's going to be something where it's going to be I've not heard it called anything other than a quitclaim deed, but it may be, but that would be a place to start. That'd be something to ask about. Is there a quitclaim deed or something like that in my state that would allow me to move forward with the appropriate notification of everyone, right? You get the last known addresses, you send the formal notes, all the kinds, you serve the papers, right? So they really have notice that they're about to lose their interest in the property. There may still be a way to move forward.
And is there like a place you would go to identify pro bono attorneys that have experience with heirs property?
The key thing that you indicated there in that question, so whoever wrote that, kudos to you, is experience in heirs property. I think that is, wherever possible, it's good to have someone who understands that, particularly with the UPHPA that's been passed in a number of states, as you saw on the map earlier. There are a lot of places where folks don't know that's the law, honestly. And so people have not been used to practicing under that, and so they're not clear about what their rights are and what their responsibilities are. One thing to do is to look in most state bar associations will have some information for the public on their website. They'll say, oftentimes it's some sort of a search engine that'll allow you to identify probate lawyers, estate planning lawyers, property lawyers, those kinds of things. You can identify that. Word of mouth is also really, really an important tool. If you find somebody who they're happy with, what's going on, they've been clear about that. Word of mouth is a really important tool. There are groups of attorneys who meet on this. Many of them are involved in practice. I don't know that they have a website, but I've actually been in conversation with them about developing something like that, because this question comes up all the time, and it can be a challenging one to answer.
And I guess similarly, are there examples of lenders who have heirs friendly lending policies?
Yeah, I'll say most of what I've seen in that falls into two categories. One is, maybe smaller communities where you kind of know everybody, and so everybody already knows you and your sibling are the children of your parents who are recently deceased. And so yeah, I don't have the proper documentation. The document didn't say that, but I know I've been knowing you all your life, right? So I can make that loan. I feel comfortable because of the relationship I have with that family. The other place I've seen is where people are trying to develop lending policies, and I honestly, everything I've seen so far in that is in development. Like they're piloting programs to figure out how can we lend in this way and do it at scale, right? Because this is the real question here, right? If you just happen to know a friendly lender, then that's great for you, but it doesn't help everybody else. What we really want to do is find ways to do this at scale. And everything I've seen so far is in development, but it is absolutely an important area of interest. And I think that's where a lot of the work, people have always known that legal work is important for heirs property. There's beginning to be a much more better understanding of how important other services are as well.
Okay, I'll let you get through a few more slides.
Okay, we're almost to the end, so I think that these are good questions. So thanks you all for keeping the good questions coming. So we've alluded to the role of financial planners already a bit. I'll just mention these as well. I think it's important to help clients identify their level of co-tenancy. People are often, they know if they bought a house, right? They're clear that they have ownership of a home if they bought a home, or the ownership of a lot or some property, agricultural property, whatever. They know they bought it. They know. What they may not honestly have thought about is their grandmother's house? And do they have an interest in that home? They really may not have thought about that. And so I think it can be helpful as financial planners for you all to ask those kinds of questions and understand where it may be. I've not been surprised, but I've definitely see this a lot where folks are like, I actually hadn't thought about. Probably we do have. I should find out. But asking people their level of co-tenancy and really asking them, like, what are the properties not only that you own, but that you might be an heir to, can be an important thing. Again, because it helps that person, your client, identify their assets and understand how they want to proceed with them. It helps prevent further fractionization. We talked about how fractionated interest is one of the two key components of heirs property. It helps reduce that fractionation. So, for example, if someone identifies that, actually, I am an heir to my grandmother's property, I didn't think about that. I know my kids don't want it. It's already going to be 1/12 by the time it gets to me because I'm 1/6, for example, ownership interest. I'm kind of making this up in this example. I'm going to take my interest and give it to my cousin who lives in that town, who I think is really interested in it. Or I'm going to give it to my niece or my nephew, right? And in that way, instead of that 1/6 interest now being 1/12 to that person's two children, your client's two children, now it stays as 1/6 and is consolidated at least a bit with the person's niece or cousin or whoever it is they intend to get it to. So again, you all can be thoughtful about that. And I'm saying give it to, it could be sell it to, right? There could be compensation for that because it does have monetary value. So that's something, again, as financial planners, you all can be thoughtful of. I just alluded to this now, but helping clients understand the value of their partial property interest. That's something, again, to be thoughtful about. And there are, of course, different ways to assess property values. Appraisals can be part of that. Sometimes there is appraisal bias, so it's something to be thoughtful about as well. But really helping families and clients understand what it is they own. Yes, I own a 1/6% interest in this property, or I own a 15% interest in it, or whatever it is. What does that actually mean? Is this something that I want to sell? Is this something that I want to give to my relatives? Is this something I want to pass down to my children? In what form? But really helping them understand the value of that. And just as the last question said, so it was a good lead into that, really helping direct your clients to the necessary professional services to help them resolve their issues. So if you have a client and they know they have heirs property, but they're arguing with their cousins about how to use it, maybe that's a place where a mediator can come in. If you have a family and they are trying to figure out how to repair their home or improve their home so that they can use it, maybe that's where financial services comes in. If they're trying to resolve it, it's they're trying to clear the title such that title then is representative of a single person or a single entity as opposed to all of the heirs that are unnamed. Then reference to an attorney is going to be really critical there as well. So hopefully we have covered all of these things and identified them. We have just a few minutes left in here, so I'm going to. I will say in the slide deck you'll see these lists of resources. There are of course many more, but these are some to start with. And so I'm happy to do Q&A. I'll stop sharing my screen and we can talk through.
How do you sell the percentage of the property to another relative?
Yeah, this is a legal transaction, right? So you would need to be able to show what your ownership interest is. All right, so we'll stick with the easy example of, the parents had two children, the parents are deceased, and now it's the two children who are heirs to the ownership. And let's say you want to sell it to the child, your sibling who's living in the property. Then that's a legal document. If it's clear and straightforward, then it's a pretty straightforward thing to do, right? You know who the two children are, you're the heirs. The attorney would document that, and then would document that you are transferring your 1/2 interest to your sibling for whatever that fee or no fee is arranged. So that's a legal proceeding. It can be very simple in the case that I just described. It could also be extremely complex, right? If you don't know what your interest is, if you can't figure it out based on the family tree, if there's uncertainty in the family tree, this is more likely to happen when there's been multiple generations of inheritance, of that informal inheritance.
And this is another specific question that one of the participants is experiencing with a client. Both her parents passed away and they have a home repair loan with the county. Any suggestions for what she needs to do in order to address that?
She says you have a home repair issue.
Loan.
Oh, a home repair loan.
Yeah.
Yeah, I mean, I think there's probably a number of ways to think about it. I think part of it would depend on who took out the loan. And so, if your name is on the loan document, then you probably should be paying because you don't want to damage your own credit in those kinds of situations. If it's someone else's name, if it's like the name of the deceased, then maybe that's part of the estate. So I think it's probably going to be something we've talked about housing counselors and credit counselors being part of this as well. It may be something where you need to talk with those folks to really figure out where is my responsibility and what my outcome is. Maybe I'm not fully responsible, right? 100% responsible, but I want to be able to continue to live in the home. And so I'm going to take this on, or I'm going to help work with my siblings to make sure this happens.
And then we have, well, we have a question on data on how much heirs property has been lost from families.
Yeah, it's a huge number. And there's quite a bit of data on that. If you read there's a primer that's leaked in the a primer on heirs property that's linked in the slide deck that talks about that. Most of the data that I've seen that talks a lot about this is particularly around agricultural properties in the South, which is why some people think this happens only in the South. But you see it as well in other places too. You see families who, maybe live in New York City and have an apartment that their family has owned for decades, and now it's worth several $1,000,000. And they've had an investor come in and they've ended up losing that property, right? So I think it depends on how you're asking the question, but it is a significant contributor to land loss. And that's a big part of the reason that UPHPA legislation is in place. It allows people to sell their interest if they want to, but it also facilitates families keeping the property if that's what they want to do.
Thank you so much. Just a few housekeeping things. So a reminder for all the CFP professionals in the audience, FFP, we will submit your CE credit to the CFP board. If you're an AFC, you can use the code FFP 17, and that's in the chat too, in case you can't understand what I'm saying. So Frank, Peter, 17, and that's the code that you can use to submit your continuing education credit to AFCPE. Next week, we'll be sending out the presentation slides and the recording in an email, but you can also check our website. And thank you all for being here today. And I want to thank Karama especially. This was an excellent presentation about a topic that I definitely didn't know a lot about, and I learned so much. And we just appreciate you so much for being here today.
Very much my pleasure. I hate we didn't get to all the questions, but please feel free to reach out to me or to others so that you can get those answers and support your clients. Thank you all very much.
Thank you so much. Have a great day, everyone.